Bueno, continuando con la segunda conferencia magistral de este congreso, tenemos hoy como invitada especial a la doctora Liu Chang de China, quien hará su exposición en inglés y las preguntas van a ser traducidas por el doctor Mario Amoretti Navarro, quien también se encuentra presente y quien ha sido parte también de la coordinación principalmente de este evento. Antes, quiero presentar a la doctora para que posteriormente pueda presentarse la doctora misma con ayuda del doctor Mario Moretti. Muy bien. La doctora es abogada por la Escuela de Leyes de la Universidad de Fudan, China. Cuenta con PhD por la Universidad Ludwig Maximilian de Múnich, Alemania. Es autora de libros y diversos artículos académicos. Es investigadora también asociada CICIP de la Universidad de Tongji, Shanghái, China. Así que, doctora, le damos la bienvenida. Doctor Mario nos va a ayudar justamente para presentarla.
Hello, good afternoon, dear Chang. I'm happy to see you. Greetings from Munich to China. Dr. Astete has introduced you to the audience, and we are very happy that you were available to participate in this meeting. I'm very happy that you are here also. So please start with your topic. The floor is absolutely yours.
Okay, thank you very much for the kind introduction of Dr. Uriel Astete, and thank you very much for the how to say that, for the translation of you, Mario. So I will try to share my slides now. Okay.
Okay.
So could you see my slides here?
It hits very well, although yes, it's perfect.
Okay, thank you. So let's start. Okay, so buenos dias, the first. So it's really a great honor to be given the chance to present my research in this international congress to celebrate the 200th anniversary of Academia Lauretana de Arequipa. And it's also a very great pleasure to meet many friends again since the outbreak of the pandemic. So, and I'm really grateful for the kind invitation of Dr. Uriel Astete and Dr. Amoretti Navarro. Thank you. So today, my topic of presentation is evidence examination and evaluation in bribery cases under the theory of mutual corroboration. So let's take a look at the provisions in Chinese criminal law at first. So according to 385 section 1 of the Chinese criminal law, public officials commit the crime of taking bribes if they, by taking advantage of their position, demand property from others, or illegally accept property in return for securing benefits for others. And then take a look at Article 383 together with Article 386 of our criminal law. These two require the penalty of the crime taking bribe be determined on the basis of the amount of the bribe and other circumstances of the offense. So, and then come to the practice. In the practice, judges face difficulties in asserting facts in bribery cases concerning the conduct of the defendant, namely whether he or she asks for property or just accepts it, the amount of bribe, as well as the defendant's intention to take bribe. because both bribe taker and payer, they are very cautious in committing the offense. They communicate with each other face-to-face, choose cash or other means which are hard to be traced as bribe, and pass bribes in private, leaving very little physical or documentary evidence to be found. Thus, judges rely heavily on admission of the accused and testimony of witness to establish facts in bribery cases. However, there are some problems here. There are often contradictions between statements of the accused and the eyewitness, namely the bribe payer or the bribe taker and the bribe payer. And sometimes there are even inconsistencies among statements made by the same person during the whole proceeding, namely before and during the trial. For example, we can imagine a defendant who confessed his or her crime before officers of supervisory commission. This institute is in charge of investigation of corruption offenses since 2018. Or this defendant confessed maybe before a prosecutor, and then the defendant withdrawn the confession and asserted his or her innocence in front of the court. Under these situations, the court needs to decide which statement of the accused or witness among several is truthful, and on this basis, what the main facts of the case are. And then to solve this problem, judges develop the theory of mutual cooperation. They use it in bribery cases just as they do so also in other cases. And according to this theory, the theory of mutual cooperation, the court can only deem a statement truthful or ascertain a main fact of the case if at least two pieces of evidence from independent sources corroborate each other. So I can provide you with two cases as examples. First case, the trial court believed in the confession of defendant X made during the investigation, although X argued for his innocence in court. The reason is that X confessed his crime during the investigation for many times and without inconsistencies. And his admission of guilt was confirmed by statements of the bribe payer and the co-accused. So corroboration here. And in the second case, it's a little bit complicated. We have three persons here: the defendant, B, the eyewitness, also the bribe payer, S, and the boss of the S, so a third person. So B, the defendant, asserted that he had returned the bribe to F, to the boss, after his failure to persuade S, the bribe payer, to take back the bribe. So I don't want to take that. So I want to be a good officer. No way. The court didn't believe in this statement out of the reason that B's assertion was not corroborated by testimony of S, of the bribe payer. And it didn't confirm with daily experience that a bribe taker just gave the bribe back to a third person other than the bribe payer without demanding a receipt from that third person or noticing the bribe payer of the return. So these two cases. So I hope you can understand how the theory works through these two examples. Okay. And our judges and prosecutors, they regard the theory of mutual cooperation as stricter than proof beyond reasonable doubt, which is recognized in most Western countries. Since this theory requires that only certain amount of good quality evidence can secure a conviction. As a result, this theory can effectively prevent wrongful conviction and improper sentence, even at the cost of setting free real criminals. However, we see false convictions emerging, keep so, and this phenomenon just challenges the belief of the judges and prosecutors. So it is worth exploring whether the theory of mutual cooperation really is a blessing for defendants and counsels. If not, if this theory has negative effect on the defense, then should we get rid of it? Also, if not, if better to preserve this theory, then how can we reform it to reduce its harm? I'll try to answer these three questions one by one in the following parts. So, to our second part, effect of this theory on the defense. To be honest, the theory of mutual cooperation is not developed to ensure an as high as possible standard for the prosecution, but to be a last resort to prevent wrongful conviction. The truth, in Chinese criminal procedure, we rarely see witnesses during trial. I can introduce an empiric research published in 2021 last year. This research analyzes more than 80,000 convictions issued between 2019 and the middle 2020 after a standard trial where the defendant didn't admit guilt and witness testimony was introduced to convict the accused. And this research draws the conclusion that witnesses testified in court in only 26 cases among every 10,000 cases. That is to say, in most cases in China, a conviction is not supported by testimonies before the court, but by prior statements of witnesses in written form. So the most important form is records of questioning produced by investigating and prosecuting authorities. Also, written statements of the accused made in pre-trial stage are used as evidence during trial without any limitation. This worrying situation has several causes. Firstly, there's almost no legal obstruction for using prior statements of witnesses, of defendants. And secondly, the prosecution. The prosecution prefers written statements to testimonies before court because the former is under control and can better pave the way to conviction than the latter. This reason plays an important role, especially in bribery cases, according to a former prosecutor. Thirdly, the court. The court is sometimes also not interested in the personal presence of witness during trial, since that causes a longer trial and a heavier workload for judges, and witness compensation and protection consumes the limited judicial resources. However, at the same time, judges are obligated to preserve substantive justice to find the truth, no matter favorable or unfavorable to the defendant. And they bear personal responsibility for wrongful conviction. Therefore, judges develop the theory of mutual cooperation to evaluate evidence and ascertain facts in spite of the absence of witnesses. So, to be specific, they assess the quality of evidence not on the basis of its substance, like the expression, appearance, behavior of a witness while testifying, but in the light of the outward features of evidence. That is to say, whether pieces of evidence corroborate each other. Since judges cannot get sufficient information from examination of written statements at trial, no matter how devoted the parties are during this process. While the mutual corroboration can be easily decided, even if judges don't hear and see witnesses at all. They just need to compare the contents of written statements. However, we have to admit that the theory is not very successful in doing its job to prevent wrongful conviction. In the stage of evidence evaluation, at first, this theory didn't block arbitrary decisions of judges, but provide cover for them. For the requirement of mutual corroboration, mutual stands for amount of evidence from the independent sources, and corroboration stands for the relationship between evidence. The former can be easily decided, while the latter not. There's no general guideline for judges to tell whether there are corroborative evidence or not, and there can be none, because it's a question of application of experience rules, which vary from case to case. Judges using the following steps to determine whether pieces of evidence corroborate each other, no matter with or without awareness of the whole process. So we have 3 steps. Step 1, judges make an inference regarding a main fact of the case on the basis of each piece of evidence with help of experience rules, which they deem applicable to this case. And then step 2, they compare the inferences already made with each other to decide whether they are the same. If there are contradictions, then the judges decide if they are crucial according to the issue in dispute and the extent of contradiction, and determine if the contradictions can be reasonably explained and thus overlooked. Here, experience rules still play a very important role. And then we come to the 3rd step. Judges determine finally if there is corroborative evidence or not. To better illustrate the whole process, I will introduce each case. In this case, the trial court decided there was a mutual corroboration, even when the defendant H confessed to take a bribe consisted of 3 kinds of notes. That is to say, the 100 Chinese yuan notes, 50 yuan notes, and the 10 yuan notes, while the witness, the bribe payer L, testified that he paid the bribe with all 100 yuan notes. So some difference here. And so from my point of view, it's not just a slight difference. Since the trial court made no explanation for this determination in judgment, I can only infer that maybe judges of the court deemed it's reasonable that people cannot remember details of a past event very clearly. Therefore, the judge overlooked the differences between statements of defendant and eyewitnesses. If the case had been tried by another court with another experience rule, maybe the court would have reached another conclusion. It's possible. So in a word, the requirement for corroboration is open to interpretation and is applied inconsistently by different judges. What is worse, mutual corroboration is here in China generally regarded as an objective standard, and it provides a perfect cover for the subjective decisions of judges. So it's generally believed that things just speak for themselves when pieces of evidence confirm each other. And here, the limited capabilities of human play no role. It's even better for truth finding. the subjective decision of judges behind the determination of mutual corroboration is totally ignored. Consequently, judges don't give detailed reasoning in the judgment for the mutual corroboration of the case. They just list the contents of pieces of evidence and then conclude they support each other. Done. So they are not to blame, are they? Because mutual corroboration is, as generally believed, not their subjective decision. Just describe how the things are and no further explanation is needed. However, that's bad news for the defense. If the convicted and counsel try to appeal the judgment, they have to point out what mistake was made in order to win the case without specific reasons for the determination of corroborative evidence in the judgment. It's not easy for the defendant, for the convicted and the counsel to locate a particular mistake made by a trial judge. And due to the same reason, it's also hard for the appellate court to review the work of the lower court. If when this convicted is lucky, the appellate court doesn't simply affirm the first instance judgment on the basis of the theory of mutual corroboration. And influence of this theory is not restricted in the stage of evidence evaluation, but extends to the stage of evidence examination. There, so I mean, in the stage of evidence examination, this theory doesn't reduce, but increase the imbalance between the prosecution and the defense. According to this theory, key issue of evidence examination is no more the quality of each single piece of evidence, but the amount of evidence and relationship between pieces. The prosecution, it has far more power and resources than the defense to collect evidence and create mutual corroboration with or without intention. Officers of supervisory commission or prosecutors, they question the accused or witnesses, they document the whole process, they decide what questions are asked and how answers of the accused or witnesses are understood. In a word, they shape records of questioning. At the very best, these records should be regarded as joint works of interrogators and respondents, while in the worst cases, where torture, threat, or other illegal means are applied, interrogators are the only author of the works. This brings huge difficulties for the defense. On one hand, there's less use, so not no use, but less use to challenge only one piece of incriminating evidence. The defense has to overturn most of incriminating evidence to win a case. So I'll introduce B's case as example. Here we also have three persons: B, the defendant, eyewitness W, and B's wife G. G, as asserted by the prosecution, actually accepted the bribe. Okay, so in this case, the witness W gave different time and place for the agreement reached by him and the defendant B on giving and taking bribe in statements before and during the trial. In spite of this difference, the trial court still deemed W's testimony before court truthful and found that B had the intention to take bribe because W's testimony was confirmed by audio-visual testimony of G, B's wife. And G didn't appear during the whole trial. So another difficulty for the defense, it has no power and few resources to collect corroborative evidence to compete with the prosecutory corroboration. A single piece of absolving evidence, even with good quality, is easily overweighed by pieces of incriminating evidence, which maybe just provides superficial support to each other. So, as a result, the theory of mutual corroboration prevents conviction of defendant in cases where pieces of incriminating evidence are obviously in conflict with each other. Whether it also works in other cases, in cases where the contradictions are slight, depends on the different understandings of the theory by different judges, which is shirted by the false objectiveness of this theory. So long as there's no conflict at all, the theory allows or even requires a conviction without discussing the possibility that there are contradictions, but they are carefully concealed by the prosecution. So then we move to our third part. So after the above analysis, we have to ask ourselves whether it's better to get rid of this theory, which is sometimes useless and sometimes even harmful. The answer of most Chinese scholars is no. This answer is backed by a good reason. Something is better than nothing. So we Chinese scholars, we have to live with the fact that the safety network protecting the defendant from wrongful conviction in China is highly incomplete and will remain so in foreseeable future. That's the background for the development of the theory of mutual corroboration and shall be ground for the discussion of its fate. According to the experiences from other countries, a safety network against wrongful conviction consists of many principles and institutions. Several among them are of special significance, like the principle of immediacy and orality in Germany, like so Unmittelbarkeits und Mündlichkeitsprinzip, this principle demands that the judge enters a judgment on the basis of the whole hearing, which is conducted orally. And during this hearing, the defendant, witnesses, expert witnesses, they are questioned in person. So no use of written statements made by these persons before trial. This principle thus guarantees an effective defense and an exact assessment of evidence by judges. And we can take a look at the right of confrontation in USA. This right ensures the accused a face-to-face confrontation of adverse witnesses, as well as an effective cross-examination. So the accused get the opportunity to check the reliability of the testimony against him or her. In Chinese criminal procedure, these principles or their equivalent are nowhere to be found. As introduced in the last part, use of written statements at trial, mostly by the prosecution, is not a problem at all. Although Chinese lawmakers and courts, they are now aware of the issue after year-long efforts of scholars and take steps to facilitate the appearance of witnesses and expert witnesses at trial. The improvements are far too slow and far from enough. According to the amendment of Chinese criminal procedure law and its judicial interpretation in 2012, the court is forbidden to use a written statement of a witness to enter the judgment if three conditions are fulfilled at the same time. Firstly, the prosecution or defense doubts the written statement, the statement can significantly affect the conviction or the sentence, and the court deems it necessary to hear this witness. So here's just the first condition. And the second condition, the subpoenaed witness refuses to testify without a justifiable reason. And the third condition, the court cannot assess the truthfulness of the statement through other means. So very complicated conditions, not so. So it's obvious that lawmakers and courts, they are reluctant to prohibit the use of written statements, and by this means force the prosecution and the court itself to call witnesses to testify in court, at least not for now. Thus, Chinese courts will continue to base convictions on written statements of witness and the accused made before trial, also in the near future. And back to our theory of mutual corroboration. It's a technique for judges to issue conviction without testimonies. It only acts as a protection for defendants when there's at least one contradiction between incriminating evidence of the case. The more contradictions there are, the more obvious the contradictions are, the more effective this protection is. Of course, that's not enough, but it's better than nothing. If we remove this safeguard before other guarantees are set, the accused will be left in a totally helpless situation. Thus, a realistic solution for now is to preserve and improve this existing safeguard, to strengthen and expand its protection. That doesn't mean that we will stop fighting the real problem, stop calling for introduction of the principle of immediacy and orality, and for completion of the safety network for defendants. So there are two things. We can do them at the same time. And then, okay, to the last part, some reform ideas. So I would like to make 3 suggestions to reform the theory of mutual corroboration. Firstly, so it's necessary to make clear that determination of mutual corroboration is a subjective decision of judges, instead of a merely description of an objective situation. This decision is made through a 3-step procedure with application of experience rules as its core. Judges are not only observers and reporters through this process, they are the decision makers. These subjective decisions should be controlled and can be controlled. So this point is very important because no improvements are possible without this fundamental change of the way that the theory of mutual corroboration is understood. Then, in the next place, in order to avoid or at least reduce arbitrary decisions of trial judges, they should explain decisive elements of their determination of mutual corroboration in the judgment. So as mentioned above, the decision-making consists of 3 steps. So the judges make inferences based on pieces of evidence, then compare them with each other and decide whether to ignore harmless differences. And finally, determine if there's a corroboration. In step 1, a judge cannot ignore but has to pay special attention to defense evidence, if there's any evidence, and inferences on this basis. In step 2, the judge has to give detailed justification for his or her decision to deem a difference between inferences reasonable and harmless. The more crucial the contradiction is, that is to say, the more important the issue in dispute is, the greater the difference is, the more detailed the reasoning in the judgment shall be. The judge must deal with doubts raised by the defense against prosecutory evidence and inferences. These doubts are recorded in the court transcript. And through formulating the explanation, the judge is given the chance to review his or her decision and the underlying considerations. That is to say, the range of evidence and inferences, the reliability of experience rules and their application in particular case. And the court and the judge, they are given the chance to replace a hasty decision with a reflected, original one. If this self-control doesn't work well, the defense can get sufficient information from the judgment to file an appeal on the ground of an error of fact. And at last, the appellate court ought to reverse a first instance judgment if the determination of mutual corroboration is obviously unreliable. That's the case if there's no explanation for the determination at all, or if the explanation fails to meet the requirements mentioned just above. To be specific, the explanation doesn't fully consider and deal with evidence and doubt of the defense, or the explanation is not understandable to a reasonable person, since the explanation is based on experience rules which are very weak or even don't exist, or experience rules shall find no application in this particular case. So that's all of my presentation. And thank you very much for your time. Muchas gracias. Here's some key points of my presentation on the slides, and I look forward to your questions and comments. Thank you.
Thank you, Dr. Chang. Muchas gracias por su participación. La ponencia ha sido en inglés, había unos subtítulos, sin embargo, no, vamos a tener una síntesis de lo que ha expuesto la doctora. Si no hay alguna pregunta, me gustaría dar pase al doctor Mario Amoretti Navarro para que pueda hacer una síntesis de esta y pueda ayudarnos también en la traducción de las preguntas que tuviéramos posteriormente. Doctor.
Muchas gracias. Solamente para nuestra conferencista, para que entienda, hablo en inglés y luego lo paso al español. First, many thanks, Chang, for your conference. Really interesting. I will make a very brief summary of your words in Spanish right now, and after it, I will address to you one question that I have. So I will talk first in Spanish, and I will turn to English after it.
Okay, thank you.
Thank you. Bueno, muchas gracias. Ante todo, la exposición ha sido bastante interesante. Yo tengo que hacer una tarea bastante difícil de resumir en pocas palabras lo que la profesora Chang nos ha explicado, haciendo referencia a una teoría del derecho procesal llamada la teoría de la corroboración mutua, y que, como ella ha señalado, puede haber pruebas de corroboración relacionadas con una determinada fuente. Esta fuente puede ser de la parte acusadora de la fiscalía o también puede ser de la parte de la defensa. Esto es la relación que tiene una prueba en relación a la fuente de donde ésta emana. Entonces, como lo que esto hace que un autor piense de una determinada manera debido a las pruebas que le proporcionan los testigos, ¿no? El autor de la interpretación de la prueba, sea de la parte acusadora o sea de la parte de la defensa. Y acá puede tener un lugar importante al momento de las contradicciones que se pueden presentar en torno a la prueba, también puede servir para subsanar o corregir el problema de la credibilidad del testimonio del testigo, en el sentido de que si una prueba de cargo es analizada de modo tal que ejerce o se interactúa en una corroboración con la prueba de la defensa, uno podría decir, bueno, acá, asumiendo incluso una falta de credibilidad por emanar de la parte contraria, esto sirve al momento de evaluar para generarle o inspirar confianza de parte del juzgador, de parte del juez, en lo que puede pensar. Este es una teoría que surge en base al problema del abuso o uso desmedido de la prueba escrita en el derecho procesal chino, en donde diversas condenas habían tenido como uso, como base principal, testimonios otorgados de manera escrita, o sea, en base al proceso que tenemos en Perú como un proceso de instrucción. O sea, un uso, como ella lo ha dicho, ilimitado de testimonios escritos. Ella ha tenido una visión crítica de esta teoría de la corroboración mutua, en el sentido de que puede llevar a que el juzgador, el juez, se concentre en la correspondencia que existe entre este tipo de testimonios y deje de lado las máximas de la experiencia o su propia evaluación sustantiva sobre los hechos que han ocurrido en un determinado proceso. Eso es básicamente, y ella, bueno, ha presentado algunas propuestas de mejora, sin rechazar la institución. Eso es básicamente el resumen sucinto, que por cuestiones de tiempo no se puede complementar. Yo tengo una pregunta que hacerle a la doctora Chang de mi parte, muy puntual, y la voy a decir primero en español para que ella nos presente una explicación luego de escuchada. La pregunta es que nosotros vemos que a través de esta institución de la corroboración mutua, pero también vemos, por ejemplo, con el uso de las instituciones como la colaboración eficaz, que el proceso penal tradicional va avanzando hacia lo que se conoce como la justicia penal negociada, en donde por un lado la parte de la defensa y por otro lado la parte acusadora, la fiscalía, se ponen de acuerdo y llegan a un acuerdo. Entonces, esto tiene como crítica de parte del derecho procesal penal de la Europa continental la pérdida del fin de la verdad material. Esto obviamente tiene una cepa, un origen norteamericano, en donde la mayoría de los casos se resuelven a través del plea bargain, a través de este acuerdo que tienen las partes. Pero en el caso del proceso penal alemán, donde le confiamos o el europeo continental, donde le confiamos al juez penal ser el director del proceso, del juicio oral, y que esto nos permita a nosotros conocer qué es exactamente lo que ocurrió como un requisito de poder aplicar el derecho penal sustantivo, y por otro lado, por una exigencia de justicia, evitar que no se aplique el derecho penal material a quien sí se le tenga que aplicar, esto, el entendimiento del derecho penal como un imperativo categórico que se tiene que aplicar a quien cometió un delito, y no se le puede decir, bueno, tú estás colaborando, entonces, bueno, a ti no te aplico el derecho penal, o te lo aplico de una manera, digamos, más benigna porque me ayudas, ¿no? Y de esa forma, pues, tenemos una sentencia que nos puede resultar a nosotros injusta. Hay muchas conferencias sobre el tema de la colaboración eficaz, no quiero en ese sentido ceñirme ahí, pero mi pregunta va en el sentido de que si no, esto no es también el proceso penal americano del en el medio europeo continental, donde podemos criticar también el uso de una fórmula prácticamente matemática de que se correlacione las pruebas de la defensa o de la fiscalía, en donde al fin y al cabo el juez se concentre más en eso que observar lo que realmente ha podido ocurrir, ¿no? Y bueno, hay otras cosas que uno podría decir, pero por cuestiones de tiempo quiero dejar ese punto acá y escuchar lo que la doctora Chang nos va a mencionar. Dear Chang, I have just summarized what you have mentioned. I will not repeat that in English because, of course, you have already said. And I have also formulate a question for you. And the question I have already translated, or I addressed my question. I said my question in Spanish in order to avoid wasting of time. And what I was thinking when I was hearing you is that as you know, the criminal procedure in Germany has been under influence of the process in the common law, and there are many professors that criticize this development, especially because the German process is structured in such a way that we try to reach the material truth, what really happens when we are when we are analyzing a criminal procedure. So the judge has a lot of power, and the paradigm in the common law procedure is a procedure of parties that they can decide among them, and the judge just administrate the due process that everybody does not break the law procedure itself. So when I was hearing you, what I thought is that this theory of mutual collaboration smells for me, looks like another development of the criminal procedure towards the direction of the common law procedure that lets the judge to be in a role as if he is just making a judgment about how many evidence has been provided by the defense that matches what has been provided by the prosecutor. So it's not like he's using his experience rules, as you have criticized and proposed to as a way of changing this model. But that was, for me, the question. If you do not see that this is also an example of the development of the criminal procedure towards the American and the UK model, the model of the common law, what could be also another problem for the defendant?
Okay, thank you very much for the question, Mario. You are right, because also in Scotland, they have something very alike. They also have the some rule of mutual cooperation. However, here in Scotland, the case is not tried by a professional judge, but by a jury. Yeah, so you're right. There's really something in the common law system. However, the theory of mutual cooperation, it's to some extent also like the evidence law once governing the criminal procedure in, how to say that, under the inquisitorial system. So Europe in the, how to say that, in the middle century. So there's also something, so maybe it's something shared by both systems. So you are right to sense, okay, it's like just like a turn to the direction of common law system. But I have to say, so the other side of this theory, it's also something exists. So from in the civil law system. So I will not regard it as a turn toward the common law system. And because in China, the situation is a little bit complicated because we have learned much from Germany in criminal law. However, so in the area of criminal procedure law, we have learned at first from Germany, but now much from USA or from England, something like that. And so there's something, so they didn't match. So we cannot have a criminal law just like in common law, in civil law system, and criminal procedure law like something in common law system. They don't match with each other. So because I also get my PhD in Germany, and so I'm relatively familiar with the German law. So in my opinion, so the future of Chinese criminal procedure law, maybe it's more in the German direction. So only in this way we can make the substantive law and procedure law constant with each other again. So you have mentioned, okay, the German law is nowadays in recent years there is also affected, influenced by the development in USA, something like that. Yeah, it's true, but I think the core features of German law, they remain the same. And that's what the Chinese criminal procedure can learn without a revolution. We just need a reform to learn from the German model, but we need really a revolution to go to the way of the USA or to the way of some common law system. Yeah, that's my answer. So hope you have answered. I have answered your question.
Thank you very much. I will summarize your answer, and after it, I will go through another one that I have just thought about it, but just hold on a sec, please. La profesora Chang nos ha vuelto a explicar con motivo de mi pregunta sobre la influencia del modelo anglosajón, que ella también considera de que es una influencia que sí, que existe en el proceso penal chino, que ella nos menciona, bueno, no es la única influencia que existe, porque el proceso penal alemán o el derecho procesal penal alemán también ha influenciado al código procesal chino, y que ella considera el futuro le pertenece al derecho penal alemán y como fuente de influencia. Veo que hay una mano levantada. Quiero solamente hacer una última repregunta y luego dejar al colega que quiere hacer la pregunta. Quiero terminarla para que no perder esta hilación de las influencias. Y luego le doy la palabra a él, si creo que sí va a haber un poquito de tiempo para responderle. Solamente mi pregunta ahora se refiere a algo que el profesor Schunemann, que tiene un un tratado de derecho procesal penal junto con el profesor Roxin, que él denomina algo que se podría traducir como la tijera de presión en el proceso penal en contra del procesado, en el sentido de que cada vez más uno va recopilando la primera parte del proceso normalmente tiene, al menos en el proceso inquisitivo europeo continental, está estructurado de una forma en la que cuando se va acopiando material probatorio, y que cuando este ya se actúa en el juicio oral, ya de por sí los órganos jurisdiccionales ya tienen un prejuicio en contra del imputado, por eso lo va llamando la tijera, en el sentido de que se va ir cerrando, y esto le afecta el balance a la defensa del procesado. Entonces, yo creo de que esto genera el desbalance procesal, la postura del profesor Schunemann. Yo quería preguntarle a Chang si ella no cree que esto también, esta teoría de la mutua corroboración, no causa el mismo efecto, y cómo podríamos mejorarlo. Luego, muy brevemente, y le doy la palabra al colega luego de la respuesta de la profesora Chang. Dear Chang, I have just make a note and a question on my next question to you, and that is, you know that Professor Schunemann has written a treaty in criminal procedure with Professor Roxin, and Professor Schunemann he criticized the German procedure because he thinks that the process creates an imbalance against the person that goes through the process, and that is for me the question. He calls that what we could say like a scissor that gets closer and closer parallel to the development of the criminal procedure. And the question is, don't you think that this institution, or this theory of mutual collaboration, also produce imbalance against the defendant? I think you have already said, but I would like just that you make this highlight to this question. Thank you.
Okay, thank you for your question, Alio. Yeah, so my answer is yes. This theory, so it is itself not so harmful for the defendant, but in combination with the trial with written statements instead of before, this theory is very harmful for the defense. As mentioned in my presentation, this theory just covers arbitrary decisions of trial judges. So this arbitrary decisions can hardly to be challenged by the defendant and the counsel, in both substantive and procedural way. And so the influence is not just for the evidence evaluation, but also the evidence examination is affected. So this theory of mutual cooperation also enlarge the imbalance between parties, because the prosecution, they can create cooperation, and the created cooperation is hard to be challenged by the defendant, because the defendant and the counsel, they lack resources, they lack power. So the defendant is put in the worse condition due to this theory in some cases. However, we also have to take a look of the bright side. So also in some cases, the theory help to prevent wrongful conviction, but only in very restricted scope. That's the reason why I suggest to reform this theory, to expand its protection and reduce its harm. So if we cannot have a fundamental reform of the whole criminal procedure system now, we can make a slight improvement. Maybe we can achieve our great goal through steps by step, not so in one, not in a very short time, but in a long time. So, and I can also mention this theory, sometimes it also increased the imbalance between defendants, because in my presentation, I just talked about the situation in bribery cases. However, it's very different. The situation is very different in cases involving sexual harassment or other sexual crimes, because so crimes of this kind, it will be, they are regarded not so harmful as the bribery offenses. So maybe the prosecution, they don't invest much in sex crimes. So the evidence, they don't collect as much evidence in sex crimes just as in corruption offenses. So maybe in some cases, or maybe in many cases of involving sex crimes, the prosecution, they cannot form a mutual corroboration. So problem in these cases caused by the theory of mutual corroboration is that we let the victims down. So maybe there's one piece of very good quality evidence, but it's not enough to establish a mutual corroboration. And in these cases involving sex crimes, the defendant cannot be convicted because of this theory. It's just in a sharp contrast to the situation of defendants in bribery cases. So it's all of my answer.
Many thanks, Chang. I think we are over time, so I will make a summary and give the word to Dr. Astete, to the law bar, and after it we will be finishing up. Y la doctora Chang nos ha mencionado que sí, que ella también cree que esto puede generar un desbalance procesal, incluso dentro de los mismos procesados. Esto se presenta en los casos de derecho penal sexual, a veces más claro, porque esa teoría no solamente se aplica en casos de corrupción. Sin embargo, esto debe generar algunas reformas, como las que ella ya mencionó en su exposición, aplicando leyes de la experiencia, dándole un rol preponderante al momento de aplicar esta teoría. Ahora, ya no hay más tiempo para dar más detalles de esta explicación. Me indica el Colegio de Abogados de Arequipa que ya para la pregunta que estaba pendiente se ha agotado el tiempo. Le pido disculpas desde ya para el colega que quería formularla, pero les hacemos mención que hay una mesa redonda al final del día de hoy, donde vamos a tratar de estar todos los presentes, y en ese momento podemos discutir cada cosa con mayor dedicación y mayor tiempo. Le doy la palabra ahora al doctor Astete para que despida a la ponente.
Doctor, muchas gracias, doctora Liu Chang. Le agradecemos por este tema tan interesante y conocer desde su perspectiva cómo esta figura tan importante en derecho procesal penal se va aplicando en China. Para nosotros es muy importante su experiencia desde el lugar de su país, así que le agradecemos mucho por su tema y esperamos tenerlas en otra oportunidad también en nuestro Colegio de Abogados. Muchas gracias, doctora Liu Chang.
He has said to you that they are very thankful for your participation today, that it was very interesting for them, and that they really appreciate to know about the experience of this institution under the criminal procedure in China, that they hope to see you again by the next time.
Okay. I hope to see you all in next time. And thank you very much for your patience and for your time. Thank you. It's special thanks for you, Mario.
Thank you. Nos agradece por la invitación. Espero volver a verlos y hasta la siguiente vez.
Muchas gracias, doctora. También quiero agradecer al doctor Mario Amoretti Navarro, que nos ayuda justamente con la traducción de las preguntas y la coordinación también en este congreso. Muchas gracias. Entonces, ya terminamos. Doctora, muchas gracias por su participación. Empezamos ya para ver la siguiente conferencia magistral, que estará a cargo del doctor Franklin Tommy López, con un tema muy importante que es sobre el delito de colusión. Damos unos breves minutos y continuamos con la exposición, con la siguiente exposición.